Hello, welcome back with the Grouchy Historian. We're continuing our series on AP Government, the 2020 edition. We're beginning with Unit 1, the Constitutional Underpinnings. Okay, so before we get started, let's go back to the beginning, the genesis of it all, as it were. What were the biggest influences on our founding fathers, their political thought, and their desire to form a system of government? They were significantly influenced by the ideas of the Enlightenment. Now, these are the four authors listed here. For those of you that have taken other AP courses, you might be familiar with some of these names. These are the thinkers that in the 16th and 17th century wrote some major treatises on representative government. They were getting away from the divine, the idea of the divine right of kings, the all-encompassing, all-powerful monarchy. Of course, the English Glorious Revolution of 1688, which had given Parliament significant powers over the British monarchy, set up what is now called a constitutional monarchy. And of course, the ideas of life, liberty, and property, an interesting concept. We'll talk more about that in a minute. But of course, merging all of these different Enlightenment philosophers together with their own experience in early colonial governments, early representative governments, the founding fathers were significantly influenced by different forms of democracy, participatory, pluralist, elite, and representative, foremost among those. So very quickly, participatory democracy, say that 3 times really fast, is exactly what it implies. It wants to have the broadest participation possible by the citizenry to get citizens involved in government. Now, I understand that there's, of course, a great deal of angst among certain modern historians that it wasn't as participatory as they would like. Of course, Indians, slaves, women did not have the vote. But for 18th century government, the American form of participatory democracy was probably the most inclusive of that time. Everything in context. Pluralist, of course, assumes that there are different interest groups, different groups of people with different stakes, as it were, in the government and in the democratic process. These would be merchants, farmers, bankers, whoever else that has a stake in good governance. Elite, of course, was more of the British style of democracy at this time. Parliament was mostly filled with titled landholders, not, of course, eligible to be in the House of Lords, but certainly rich landowners, rich businessmen, not your average blacksmith or cobbler. And of course, the biggest concept that the colonies experimented with before the American Revolution was representative democracy, right? Where they elected representatives for whatever they called their particular legislative body, the House of Burgesses in Virginia, for example. There was at smaller maybe on a town meeting level, there may have been a pure democracy where they put things to a vote. But generally, most of the colonies had some sort of representative legislative branch that worked with the royal governor to pass laws and govern the colony. Now, where did the Constitution directly come from? Well, of course, as the colonies start with their break with England in the tense political period after the French and Indian War, when the British Parliament passed various acts in an attempt to get taxes out of the colonies to help pay their enormous war debt after the French and Indian War, the colonies determined that they needed to have some sort of unified stance to protect their rights against what they saw as an increasingly tyrannical monarchy and parliamentary government from across the ocean. So the First Continental Congress in 1774 was the first attempt at genuine political unity by the colonies. It was more of what I would call an extended meet and greet. They didn't pass, they didn't attempt to form any genuine form of government because, of course, at that time, that might have been construed as treason against the crown, but they at least got all the colonists talking together and determined where they might have common interests. Of course, primarily in asserting their rights before the crown and parliament. Once the war broke out, the Second Continental Congress, in session from 1775 to 1781, not only declared independence from England, but tried to manage the Revolutionary War. Mostly poorly, to be honest. And they passed the Articles of Confederation, the first American system of government. Now, keep in mind that the Articles of Confederation took about 5 to 6 years, 4 to 5 years to pass. Now, of course, there was a war going on and all that, but the Articles of Confederation were not passed by all the colonies until 1781. Now, of course, the colonies tried to actually rule themselves after their independence from England and the Treaty of Paris in 1783. But the Confederation, the Articles of Confederation, the Confederation Congress had a number of limitations, which we will talk about in the next couple of slides. Therefore, in 1787, spurred on primarily by James Madison, a group of the best and brightest, as it were, from the colonies, including many members of the First and Second Continental Congresses, decided to get together to amend the Articles of Confederation. At least that was their public effort. In reality, they were there to launch a covert coup against themselves. Yes, that's correct. It was a covert op to not amend, but supplant the Articles of Confederation. Those members of the Confederation Congress termed that it simply wasn't working, needed to be replaced. So they got together in 1787 to begin the process of writing what would become our Constitution, which of course led to the first president and the first Congress in 1789. And what we'll find if you read histories of that time is that the Constitution itself, if you read it, is pretty sparse. So there's a lot of details that had to be worked out during that first American, we'll just call it first American administration of George Washington and the first American United States Congress. Okay, so this is a list of some of the challenges faced by the Articles of Confederation and some of the requisite changes that were made in the Constitution. Now, the biggest one to see here is that Congress really didn't have the power to, let's just say, force people to do anything. There was a lot of requesting, which didn't really work during the war for sure, and didn't continue to work well after the war when we faced our own crisis of having to A, pay our own huge war debts from winning our independence from Britain, but more importantly, a couple of things. One, there was no way to collect taxes. We already mentioned that. But more importantly, there was no one to arbitrate or, let's just say, lay down the law between the various states. Remember, at this time, the states were very jealous and protective of their own rights to tax, to regulate commerce, to pass their own laws. So we had 13 little fiefdoms with a loose confederation, hence the word. But they were all extremely jealous of their own power. And as you can see through some of here, there was the Articles of Confederation had no control of trade between the states, no system of arbitration, and most importantly, 9 out of 13 states were needed to approve resolution. This is extremely unworkable. More importantly, there was a lot of political dispute because every state received one vote regardless of its size. We'll see during the debates over the Constitution that this was one of the most contentious parts of drafting the Constitution, is the balance of power between the large states and the small states, resulting in the Great Compromise that set up a bicameral legislative body, the United States Congress, consisting of a Senate or upper house where each state is represented by 2 senators, and then a lower house, the House of Representatives, where the number of congressional delegates that each state, or I'm sorry, number of congressional representatives for each state are determined by the size of the population of the state. It's proportional representation. More importantly, is Congress now had the right to levy taxes. They had the ability to control interstate commerce, which means states couldn't try to impose tariffs on each other, which was a terrific problem in the days before the Constitution. And of course, sovereignty now, you would establish the system of a federal sort of government, which we'll talk about in a little bit. But the Constitution was the supreme law of the land. And of course, the ability to amend the Constitution, which has been done about 23 times, we'll go over those in a minute, and the ability to pass laws was made much easier so that business could get done. As you can see, 50% plus one of both houses, plus the signature of the president, is required to pass most laws. Now, of course, there are some tweaks to this. We can talk about that in a minute. The most noticeable of those being the Senate filibuster, which you probably hear a lot about in the news these days. But as it was originally set up, the legislative body was a very well-balanced machine meant to protect the rights of big states, small states, protect the purview of the legislative body versus the executive versus the judicial. We'll talk about that a little bit more. All of this was set up directly to fix the problems that the founding fathers had seen in the Articles of Confederation. Okay, again, just a quick review, pure democracy versus republic. Now, this is important because, interestingly enough, the colonies, the United States, did not set up a parliamentary system of government like the British had had, right? In Britain, they have a parliamentary system of government. So when you have a national election in the government, the party that wins the most seats in parliament has the ability to, quote, form a government, right? The king or queen in this case will call the leader of the party. In England, they have conservatives and liberals, or labor, conservative and labor, sorry, will call the head of that party in and request that they form a government. Now, as long as that party is in power, they pretty much have unlimited power to make laws. If you're the head party in a parliamentary government, you have nearly unlimited power. The minorities have a few protection, but not a lot, right? So elections are very hard fought because in a lot of these situations, one party will not win an outright majority. This is really true in countries like Israel, where you have these little parties that may have 5 or 10 seats in a 120, 130 seat legislative body, but they have tremendous power because neither one of the bigger parties has enough of a majority to form a government. So our Constitution was set up to avoid some of these pitfalls. Now, again, part of this was in the beginning, and as George Washington warned against in his farewell address, there was a desire also not to have political parties. The assumption was we're all Americans. Yeah, that worked out real well. Anyway, so this is a slide here just to discuss the ideas of a republic versus a pure democracy. Most importantly, a republic's most unique feature is that it has a constitution that enables it to protect the minority from the minority, okay, by interpreting and, if necessary, overturning laws. Again, this is the job of the United States Supreme Court and the lower federal court. Again, there are we're a constitutional republic with a definite Bill of Rights that says that you have certain rights no matter who's in power. More on that in a little bit. Okay. So this is a very quick outline of the Constitution, right? You have the preamble, and then you have 7 articles. Again, the Constitution is not very long. It's not a lot of detail. It doesn't go into all the nitnoids about you got to do this, then do this. Now, it sets out the very basic, fundamental framework of how the government is going to run, with the assumption that the colonists, the first legislative body, the first president, the first executive, would have to kind of figure the rest of it out as they went. So these are the major articles, right? So you have the legislative branch, the executive branch, the judicial branch. Very important, the relations among the states, how to amend the Constitution, right? Debts. One of the biggest selling points of the Constitution put forward by the Federalists was that it would allow the government to not only pay sort of the United States war debts, but part of the deal, because there's always a deal, is that the federal government would assume all the states' debts as well, because the government would have the ability to levy taxes to pay them. So yes, taxes, money, it's always about the Benjamins, although we didn't have Benjamins back then. There's always the money that greases the government. That's just the way it is. However, one of the other key features of the Constitution is this idea of the separation of powers and the balance of powers, right? So this little table that I grabbed here off the internet shows that where you have the little green checks, these are the constitutional roles or powers of the various parts of the government. For example, the legislative body creates laws. The president may sign or veto a law, which can be overridden by a 2/3 vote in Congress. And of course, the Supreme Court, the judicial system, can find these certain laws unconstitutional. That's, of course, one of the major cases that you will be studying for AP American Government, Marbury versus Madison, and later McCulloch versus Maryland, that the Supreme Court has the supreme power, so to speak, of judicial reviews of certain laws. So you can look at this chart here and you can find, that there are certain powers, but there's, again, a check and balance. For example, passing a budget, the legislative body passes a budget. Again, the Constitution very clearly says that all spending bills, anything to do with the money, originate in the House of Representatives. And then they do the Senate, and then there's this whole convoluted process, which I'm sure you will detail in class of, if you've ever seen the Schoolhouse Rock, I'm just a bill. Yes, I'm only a bill, right? It's a very convoluted process by the time a bill actually becomes a law. Fun fact, it's meant to be that way. People are like, why can't we ever get anything done? All they do is fuss and fight. They just feed. We can't get anything done. Can't get anything done fast. Believe it or not, it's meant to be set up that way. Yes. It is meant to be deliberative. It's meant to foster compromise, and it's meant to foster a coalition of broad support for laws that are made by the legislative body. The exceptions, of course, being during wartime, right? But for the most part, it's intended to be that way. It is a feature, not a bug. Now, of course, this does not mean that we need to have the knockdown, drag-out food fights that never get anything done. But the Constitution was set up to ensure that all of the people could be heard, all of their needs taken care of, and that everybody would feel included. All right, some other constitutional principles. Again, not only is the Constitution is all about the balance of power, we'll call it, the diffusion of power, horizontally between the branches of government, and most importantly, vertically between the federal government and the states. Again, one of the very first amendments to the Constitution was the 10th Amendment, which basically said that anything that was not specifically put in the Constitution for the federal government to do was reserved to the states, right? Again, the states were still very jealous of their particular power, so they didn't want to give it all up. They gave up the things that they all agreed were probably best handled at a national level. But there is still the balance of power between the federal government and the states, and we still see that today. Consent of the governed versus will of the majority. Interestingly enough, in the very first couple of drafts of the Declaration of Independence, it did not say life, liberty, and the pursuit of happiness. It said life, liberty, and property, which is a direct quote from one of the Enlightenment thinkers. Again, to our founding fathers, property rights were fundamental to a free society and a functioning democracy. The government did not have the right to take your stuff, which is why they were extremely sensitive about taxes, because taxes is basically the government taking your stuff. Now, there are, of course, we can debate all day on what the government should and shouldn't do, right? We still have these debates, vociferous, passionate debates, but in the time of the founding fathers, the idea that the government could confiscate your property was so baked into English common law at that time that it was a bedrock principle of the early American government. Again, the checks and balances between the branches of government, between the states, federalism, extremely important. The 10th Amendment is alive and well these days and highly debated. Okay, and I have a little quote here from the Heritage Foundation Guide to the Constitution. Of course, one of the premier constitutional books in my library. The recognition of the distinction between constitutional law and the Constitution itself produces the conclusion that constitutional decisions, including those of the Supreme Court, need not be seen as the last words in constitutional construction. Why did I put this here? Well, there's a lot of people that are really big on precedent. Oh, we got precedent. In fact, one unnamed, less than, in my opinion, highly intelligent member of the United States Senate, loves to use the word super duper precedent. Well, if we had like super duper precedent, then you have never overturned segregation. Remember, two of the cases you're going to look at here is Plessy versus Ferguson and Brown versus Topeka Board of Education. Plessy versus Ferguson is really an extension of the Dred Scott case that said that, well, first of all, slaves at the time were not citizens and had no rights. Well, the 13th, 14th, and 15th Amendments to the Constitution took care of that. Plessy versus Ferguson said you could have separate but equal. In other words, you could institutionalize, as it were, segregation of the races, which is what happened until Brown versus Board of Education came along and said, no, that is unconstitutional to segregate the government, to segregate the races. So the idea of certain Supreme Court decisions, which again you'll review, such as Roe versus Wade, as being precedent set in bedrock forever, unchangeable, is just not historically true. Think about that. But of course, even if the Constitution was passed, it wasn't over, because back then people like to argue politics like we like to argue football, because of course there was no football. So would you sit around and discuss at the tavern? Well, you can discuss farming a little bit, but that must have been boring after a while. So they discussed politics a lot. So after the Constitution had been passed and signed by the delegates, it still had to be ratified by 9 of the 13 colonies. And of course, not everyone was highly in favor of it. In fact, there was a very large block of people that thought the Constitution was not good. They thought that it would consolidate too much power in a national government, which of course they just fought a revolution to get away from. And they did not think that it would protect the liberties of the people. So you have a series of essays called the Federalist Paper, penned by primarily by Alexander Hamilton, John Jay, and John Madison, to defend the Constitution and to address the many concerns raised by the Anti-Federalists. So you have sort of this he said, she said sort of deal, where the Anti-Federalists would raise a question and say, well, what about this? And the Federalists would attempt to answer it. These are the Federalist Papers that are listed in your course material as answering some of the most important ones. But there were 85 of them addressing a wide range of issues, very fascinating readings. And lest you think, well, who cares about the Federalist Papers? Those were written a really long time ago. These are used when the Supreme Court goes back to review certain constitutional questions. The Federalist Papers, and I'm sure to a lesser extent the Anti-Federalist Papers, are used to get into, if you're a proponent of the originalist school of constitutional thought, what were the framers thinking? What were they intending to do? If you look at most of the Constitution, including the Bill of Rights and the first sets of amendments, they've held up pretty well for 200 years, for the most part, right? So again, look at those Federalist Papers. That you can find them online in lots of places, but read those and think about them in the context of our Constitution. Again, these are the ones listed here. Okay, Brutus number 1 was, of course, the first Anti-Federalist paper that questioned the underpinnings of the Constitution. So they picked these 4 to discuss factionalism, the separation of powers, the executive branch, lots of discussion among the Anti-Federalists. They did not want a king. They were afraid that the chief executive would tend to become a monarchy. And of course, George Washington, as the first president, was very aware of this, and he worked very hard to be the not monarch. So these are the ones that are mentioned in the study guide. Presumably you will go over those in class. I offer them for you here. Again, there's some other topics here. I just kind of listed these here, the Anti-Federalist, Federalist Papers that discuss these. Again, as you can see, things like states' rights, Bill of Rights, taxation had a number of Federalist Papers written about them, as did the House of Representatives. Again, the Bill of Rights was something that was brought up very early on. And in fact, there had to be a promise by the framers of the Constitution that as soon as the Constitution was ratified, the first thing they would do is pass the Bill of Rights, which they did. These are the first 10. My assumption is in class you will go over some of these in a great deal of detail. Of course, the First and Second Amendment, always fun, always applicable. even today. The Fourth Amendment is constantly debated as well, and there's other aspects, particularly the right to a trial by jury, the protection from unfair punishment, and the all-important number 10, which tends to get overlooked quite a bit, that says that all powers not specifically delegated to the federal government in the Constitution are reserved to the states and the people. Sometimes the federal government tends to forget that. So that's the first part, the first unit here. Remember, everything else that we discuss is kind of derived from the Constitution and how the Constitution has changed and has affected American government and American life since its ratification in 1791. All right, hopefully this has been helpful. We're going to kick off our next video talking about favorite topic of mine, mass media and public opinion. See you then.